Ladies and gentlemen, welcome back to the IndieZone. My name is Kathy. On the 7th of January 2025, the defense filed their reply to the state's response objecting to the defendant's motion to compel ICR, that's Idaho Criminal Rule 16b7, governing the submission of expert witnesses, what they need to disclose, and so forth, material, and for sanctions. Now, just by way of background, how filings work is that an initiating party, here Mr. Kohberger, files a motion that kicks things off. Here it's a motion to compel better answers than what has been given per the Judge Hippler October 9th, 2024 order, bottom of page 2, governing expert disclosures. And also they're looking for sanctions. Their argument that they continue to proffer here in this reply is that the state's disclosures did not comply with the court's order and this rule. The state of Idaho shot back with their response, which is the second item in the sequence, objecting to this motion, saying, Judge Hippler, you must deny this motion request. No order should be entered against the state because the state's responses of and disclosures of the 18th of December 2024 were adequate under the rule governing the disclosure of expert witnesses and this court's order. The last item in the sequence is the reply, where the defense is now coming back and basically saying, Judge, what the state's position is in their response is completely wrong, and these are the reasons why you should enter an order compelling them to produce this material to the defense. Their argument, they begin right away. This is a constitutional argument under both the 6th Amendment to the United States Constitution, the 14th Amendment to the United States Constitution, and also the Idaho State Constitution. The constitutional arguments you see here a couple of times in this filing, beginning with the second paragraph. Mr. Kohberger is protected under the Constitution of the United States and the state of Idaho to a right to a fair trial. That's a 14th Amendment argument. To confront his accusers, 6th Amendment. The presumption of innocence, this is a constitutional guarantee that every criminal defendant has at every stage of the proceedings. He is presumed innocent despite the extreme severity of the charges that have been brought against him. He has 5 criminal felonies, burglary, and the unaliving of the 4 children. He has been charged with 5 criminal felonies. He is presumed innocent until or unless one of 2 things happen. Either he pleads guilty or is adjudicated guilty at trial, which is currently scheduled to commence per the order of October 9th, in my opinion, on July 30th, 2025, which is the start of the selection of the jury panel, although that trial order says the trial really doesn't start until August. I've given my opinion, which I give under the First Amendment, that really the start of trial is voir dire when the process of jury selection happens. In any event, okay, so we see the 14th, the 6th Amendment. He has a right to a fair trial, to confront his accusers. He is cloaked with the presumption of innocence, and he is also entitled, bottom of page 1, going to page 2, to right to effective assistance of counsel. What the defense is arguing here is that no way, shape, or form are they saying they are not effective. What they're saying is, in order to be effective, they need proper disclosures. They need to be able to understand what these expert witnesses that will be providing testimony against Mr. Kohberger, in which he has a right to confront, he needs to know exactly what their expert opinions are. And the next couple of pages go into the fact, at the top of page 2, Mr. Kohberger cannot fairly confront the evidence the state intends to bring against him when he does not know what it is. He then goes into his counsel cannot be adequately prepared to represent him at trial given the state's lack of adequate expert disclosures. They then say that failure to properly disclose expert opinions by merely disclosing a list or topics an expert may testify about or leaving open-ended opinions, in essence, shifts the burden to Mr. Kohberger. We're at number one, we're at a bit of a disadvantage as the public because we don't have access. The next section describing the court has the state's sealed exhibits S's and SAM 1 to S's and SAM 25. They're all under seal. We do not have access to those, although we were given some kernels of information in the state's objection. So if you have not yet read that document, I do suggest that you do. And also, please listen to the two prior presentations that we have provided here at the IndieZone on what the defense's position was in their motion and what the state's response was. That state's response and objection provides information on what is in some of these under seal S as in SAM 1 through S as in SAM 25 expert disclosures. So do take a look at that filing. There's information in there that is being released to the public for the very first time by the state. This is what the defense is arguing, that those exhibits, the disclosures, are general. The state of the discovery responses, which the state talked about in their response in opposition, the defense here says it's in a state of disarray. They've made this argument before that there's multiple terabytes of information. The defense shouldn't have to go in on a fishing expedition and pull out what those expert disclosures are in prior discovery responses, all of which again are under seal, as are all of the discovery requests, all under seal in this case. But they're describing a situation where what has been disclosed does not meet the criteria for the defense to be able to properly put on a defense, and it's violated Mr. Kohberger's constitutional rights. Again, we're at a disadvantage because we're not able to see what those exhibits exactly state. They go on to conclude here, Mr. Kohberger must be able to confront the evidence against him, and to do that, it must be disclosed in accordance with Idaho Rule 16 and this court's trial setting order. The state has already given their position that they believe that they have complied with both, but there was a caveat at the end. Hey, Judge Hippler, if you conclude that we inadvertently did not disclose in the way that we should have, please give us an opportunity to amend, and we will. The defense goes on and says this is a capital murder case and compliance with the rules of discovery are not optional. Mr. Kohberger is prejudiced by the state's failure. It is impossible for him to confront unknown expert opinions with his own expert disclosures by January 23rd, 2025. And what this means, this is a reference to the October 9th, 2024 court order again, because how it went was the state who bears the burden of proof is to disclose their expert opinions first on or before December 18th, 2024. That the defense is arguing these disclosures were inadequate is the subject of their motion. Then, based on what the defense disclosed on the 18th of December, also per that court order, the defense is rebuttal witness disclosures. These are the experts who will now come in and say, nope, the state's opinions are wrong here, and here's why. They're due January 23rd, 2025. So what the defense is saying here is, look, we're prejudiced. We're shooting in the dark here. We don't know what these witnesses will testify to. At trial, judge order the state to provide better disclosures and also sanction them because we're prejudiced now. We're not able to meet our obligation under the court order and the rule by January 23rd, 2025. So we have two very divergent opinions here, as we have seen time and time again, about the only thing that the parties have ever agreed on is the gag order, which they have very vigorously fought having be set aside when both the Goncalves family made an attempt to do it and the media coalition, the interveners, they were on the same side that that gag order, the non-dissemination order, should remain in place, and also that so many documents should be under seal. That is the only areas, in my opinion, that they have ever agreed on. Here we see very, very divergent opinions. It will now be up to Judge Stephen Hippler to make this call, if these disclosures were proper or not. This will now conclude this episode of the IndieZone. My name is Kathy. Thank you very much for joining us here today.